The court has sort of offered something of a kind of formula for deciding if a particular group is entitled to strict scrutiny. It will essentially sort of tick through those characteristics. Has this group suffered a history of discrimination? Does the characteristic which unifies members of the group, is this an immutable, meaning unchangeable characteristic? Is there a degree of political powerlessness that this group has been subject to or has not been able to fully exercise political power? And does the characteristic have any meaningful connection to the ability of members of the group to, say, contribute to society? In some ways, so the court has had a number of cases in recent years that have involved distinctions drawn on the basis of sexual orientation. The court has actually not ever gone through this analysis in any of those cases. It has rather found in each of those really important cases that the laws being challenged actually failed rational basis review. So they did not survive even the deferential standard that we have been talking about throughout. So an important early case in this sequence is a case called Romer versus Evans from 1996. That case involved a Colorado law, actually a Colorado constitutional amendment, that responded to moves made by some cities in Colorado that had passed anti-discrimination ordinances that included prohibitions on discrimination on the basis of sexual orientation. And on a statewide basis, Colorado changed its state constitution to prevent localities from protecting LGBT individuals. So there's no gender identity protections in this law, but from protecting individuals on the basis of sexual orientation from discrimination. This law basically singled out lesbian and gay and bisexual individuals and said they cannot be protected from discrimination. And so a constitutional challenge was brought to that law. And the court basically said, there's nothing in our tradition that allows a law like this, a law that singles out a particular group and removes protections from them. And this law was motivated very clearly by one thing, and that was animus, right? That was dislike or bias against a particular group, here against individuals on the basis of sexual orientation. And that cannot supply a rational basis for a law. And so the court didn't go through the four-part analysis. One other important case to mention is Lawrence versus Texas from 2003, in which the court struck down state laws, and there were state laws like this on the books as recently as 2003, that banned adult consensual same-sex sexual intimacy. The court held that those laws, like a Texas so-called criminal sodomy statute, was unconstitutional, but again, did not announce that that law was subject to strict scrutiny. That's, you have Romer versus Evans, Lawrence versus Texas, the case striking down DOMA, or the Defense of Marriage Act. That was United States versus Windsor. In that case, the Supreme Court struck down this law that essentially required the federal government to treat as unmarried even individuals who were lawfully married under the law of their states. Because by 2012, when Windsor was decided, there were a number of states in which it was fully lawful to marry someone of the same sex. But this federal law said, well, when you're filing your federal taxes or for purposes of federal benefits, the law will treat you as unmarried, even if you are lawfully married. And the court struck that law down. In the wake of Windsor, a number of other states moved to permit marriage equality, and a number of lower courts, essentially applying the logic of Windsor, struck down their own state's prohibitions on same-sex marriage. By 2015, when the court heard the Obergefell case, which involved consolidated cases out of a number of different states, the country was sort of a patchwork, but in more states than not, there was a right to marry regardless of sex, but there were still a significant minority of states in which the laws still did not permit individuals to marry someone of the same sex, and which did not recognize valid marriages that were same-sex marriages that were performed elsewhere. The Supreme Court heard this case in 2015 and announced that the right to marry encompassed a right to marry someone of the same sex. In some ways, much like the Loving opinion from 1967 that we talked about at the beginning of this conversation, the Obergefell opinion, that's the marriage equality opinion, rests both on principles of liberty and principles of equality. Loving itself, the opinion in that case, figures very prominently in Obergefell, but the court really focuses on how fundamental the right to choose whom to marry is, how fundamental in shaping a person's life and destiny it is to identify the person that they marry. So the interpersonal and symbolic significance, but also the incredible practical consequences of being able to marry. In particular, Justice Kennedy, the author of The Majority Opinion, really focused on the consequences of being denied the right to marry on families, on children who are already living with and being raised by same-sex couples, but whose parents were essentially relegated to second-class status in the eyes of the law in the states in which they resided. We've talked about kind of the constitutional standards of review in a way that suggests that, they exist and that they're distinct. And the court sometimes, I think, uses and talks about them in ways that make clear that they're quite distinct and different. Obergefell is a case in which it's a little bit difficult to sort of identify exactly what it's doing in terms of the kind of review that it is conducting. But it very much explains that the right to marry is a fundamental right. And all of the things that make the right to marry a fundamental right are equally true if the person that you wish to marry is a person of the same sex, as they are if the person that you wish to marry is a person of the opposite sex. The right to marry is fundamental, and the right to choose whom to marry cannot be abridged or denied on the basis of sex, right? Says the court in Obergefell, but once again, without announcing in any kind of formal way that strict scrutiny applies because the law draws a distinction on the basis of sexual orientation. Here it is more the fundamental right to marry that is the heart of the opinion, but with quite a bit of language and logic of equality principles as well. I think along with Loving, in terms of opinions that are about the liberty guaranteed by the Constitution, that is one of the most important that the court has ever decided.